afternoon, everyone. I'm usually very loud, so I don't use mics, but okay. I hope this is audible to everybody.
You may be louder.
Okay, all right. Good afternoon. So I think Gaurav ji contacted me, and the idea of my presentation is to introduce the concept and topic of arbitration to a room full of chartered accountants, and focus then on areas where chartered accountants can see themselves as participating in arbitration proceedings. And just like engineers, technical members, experts on valuations today, I think we are seeing increasing interest from chartered accountants in the arbitration proceedings that go on. So I thought I will talk about that. So very quickly, I mean, I'm assuming a lot of you will know basics and the concept of an arbitration, but very quickly, what is an arbitration? I mean, arbitration, or what is an arbitration agreement? How does it happen? It's effectively a private dispute resolution, so you don't go to court for it, you're outside court. But how does it arise? It arises from a contract. It cannot arise without a contract, and I think that is the most important starting point for it. That two parties need to agree that we are going to have an arbitration and we are not going to go to court. So that's why the starting point is that it's a private dispute resolution process. Typically now, I mean, how it starts is that, and how it started is that it became a mode for settling commercial disputes. We have as a subject matter several things which you cannot arbitrate. So you can't take your family disputes to arbitration. You can take them to mediation. You can't take them to arbitration. There is controversy still on what parts of insolvency winding up can go to arbitration and what part cannot. Most of it cannot, but there are some parts of the contractual commercial dispute within the insolvency process which can. Issues like fraud, I think courts have struggled for several years. Now again, there are decisions of the Supreme Court which say that if something goes to the root of the matter and it's a fraud, unlike the old view where only courts were going to look at it, the arbitration as a private forum mechanism, they're going to. So over the last 50, 60 years, the scope of arbitration has been increasing, and as a consequence, the scope of disputes which are getting decided in courts is narrowing within that space. So more and more parties are taking their commercial disputes to arbitration instead of courts, and we'll see why that is happening as well. So that's a quick sort of a slide on major differences between arbitration and litigation. One key advantage that parties see is that everything is confidential. Now, the degree of confidentiality in a country like India still at a practical level is questionable, but as a concept outside India, the confidentiality is the key, and it's taken to a very serious level, including the fact that lawyers don't even disclose the names of the parties that they represent in an arbitration unless the award subsequently lands up in a court dispute, and then the names become public. So that's the degree of confidentiality that attaches to high value commercial disputes. Companies don't want to sort of tell everybody that we've had a dispute. A large part of it, yes, gets published in their annual reports if these are listed entities, but there are sort of certain provisions by which they can they can assert some degree of confidentiality even on that ground. Cost, at a practical level, I think that concept is changing. Initially, to start with, arbitration was seen to be cheaper than courts, and that is why parties were being pushed to do more of arbitrations, because a matter in court which was taking a commercial suit in Delhi High Court, if something is more than 2 crores, so you can go to Delhi High Court if something is more than 2 crores in terms of a dispute. Prior to the Commercial Courts Act of 2050, it would take anywhere between 7 to a 20-year, and I mean, in some cases, the lawyers and the system could just drag it on for more than that as well. But I think things on that front are changing, which is why on the speed aspect, while the concept was that this will cost you less, I don't think practically it has played out as that. Arbitrations today are very expensive. Timeline, yes, is a certain benefit. Under the Act today, you have the tribunal has to complete the pleadings between the parties within 6 months, then you get 12 months, then 6 months extension only with consent of parties, and another 6 months only if you go to court. So by and large, the default time period that you have in an arbitration is 6 months of pleadings plus 12 months plus 6, and plus 6 you go to court, but that's a 2-year horizon over which you see a matter getting concluded. Yes, please.
We have seen the client's case, the arbitration case is pending for the past 6 years.
But those will be all under the older version. So this time limit concept has come in only in 2015. 2015.
But the case was starting only 2018 only.
It depends. So, okay, so I'll answer that question clearly. So, there is a provision in the Arbitration Act 29A. For the first time, the legislature introduced this provision to introduce timelines. Now, it came in 2015, and then this entire controversy started that will it apply to pending cases, will it apply to pending arbitration, court proceedings, and the court then effectively settled this saying, I think the date is 23rd October 2015, that if your notice of arbitration is prior to 2015, so the dispute that you're talking about is 2018, possibly the notice of arbitration in that was given prior to 23rd October 2015, which is, then I don't know what the team is doing, yes. It should not. So, I mean, I cannot advise, but I mean, if you're involved and if you want to sort of ask people questions, you must, which is that if the timeline is 6 plus 12 plus 6 plus 6, possibly the mandate of the tribunal has also expired if you have not applied for an extension of time. Possibly. There is a provision, you can go to court, like you can go, so let's say it doesn't finish in 24 months, you can still make an application and tell the court that the tribunal is asking for 3 months more time to write an award or 4 months more time. But if you're saying you're sitting from 18 to 24 and it's been 6 years and this is post 2015, there is a problem which somebody needs to identify and solve, is what I can say.
What I'm saying is, in the arbitration, these are the lawyers' pay.
Yes, sir.
And they have paid the fees beforehand, at the time of start of the arbitration cases. Don't you think it was their responsibility to tell the parties that their tenure has stopped, and they must deliver the judgment?
Sir,
They have not delivered the judgment. Then what was the use of starting the arbitration?
I think that's slightly digressing. I don't want to give a view on what somebody should have done, should have said, but
What I'm saying is that we have to.
Sir, let's understand the law. आपका जो why your case is pending, when the law is clear, now you know the law. I think you can speak with the client that the order.
I think it's important to be.
Sir, she cannot advise on a personal issue. Sir, we need to understand that is a very specific issue. Until as you bring the file and discuss each and every aspect.
I mean, you'll have to reach out to a lawyer and maybe get a second opinion from somebody else is what I would suggest. So the timeline is covered, and then we have the appeal process. This is also a very distinguishing feature between courts and arbitration. So in courts, what you have is appeal. So you get a decree, you have a first appeal, in certain cases you have a second appeal, and you have avenues right up to the Supreme Court. What is important to know is the scope of that appeal. In a court matter, the scope of the appeal is very wide, which is that anything that that a lower court does wrong, the superior court, while the matter comes in an appeal, can undo and look at. This is something the legislature, and I mean not the Indian legislature, our law is modeled on the UN Citral model. This is where they introduced a limited scope of challenge. So it's not an appeal procedure. An award, once it comes from an arbitrator, is binding. And the legislature then gives you very limited grounds of challenging that award, because they don't want this to become a parallel to an appeal, that you get an award and then you treat it as a court decree and you continue to do 5 rounds of litigation and exhaust the parties. So today, if you have an award, there are very limited grounds. The provision is section 34 of the Arbitration Act. The nature of the grounds basically is that if something is extremely wrong, extremely perverse. You can't say that the arbitrator interpreted the contract in this manner while it should have been in the other manner. Which is, so the settled law is that if there are two views possible and the arbitrator has taken one view, it's okay, we are not going to interfere. If there is something which is on evidence, we will not interfere because the arbitrator is the master of the evidence. If there is something on first principles of law, you will have to demonstrate to court that there is something which is fundamentally wrong with law. So for instance, let us say the arbitrator says this is a contract, and you say that the evidence never showed that there was any contract between the parties. So that is something which fundamentally the arbitrator got wrong, and the concept and the word they use is called perversity. So you have to find perversity in an award which the courts say should shock our conscience, and only then we will consider interfering with an award, because the mandate of the law is that you have chosen Mr., Miss X, Y, Z to decide your dispute, and too bad if they got it wrong a little. We are not going to get into it. Yes.
It is not always possible to at least initiate an allegation of bias, so and then prolong the process again.
It's not so easy because the statute has provided very defined contours of what is bias, what are grounds of bias, at what stage you bring it in. The detailed schedule, Schedule 5, Schedule 7, one schedule if you fall in any of the entries. For example, if an arbitrator, so there are two lawyers, there's one arbitrator, two parties, and for one of the parties, the arbitrator is acting as a consultant or an advisor. It's an entry in the schedule which bars him, and he's automatically disqualified, which means as a party, you know, the other party, you know that he's disqualified, you can raise that ground, he'll be out of the scene. If you don't raise it, assume you don't raise it, you are either ignorant or you don't know, whenever this award goes to court, the award will be set aside for the asking, because the arbitrator from day one was disqualified under the law.
So when you say it goes to court and it sets aside, so is it that the court gives a direction that again the arbitrator is to be appointed?
No, so that's a good question. Typically in a case.
Can you repeat your question on mic for everyone?
Right, sorry. The question was, when because of any reason like bias we talked about, the court decides that there was a bias and the award is set aside. So what happens next?
Yes,
So
yes.
whether court takes it over from there or directs another independent arbitrator to be appointed in the opinion of the court
Correct.
itself.
Correct. So a couple of options as they play out. I mean, forget the ground of bias. On any other ground, let us say you have a good award, the party challenging is able to make out a ground that there was no evidence in this case for this claim which the arbitrator has awarded. Please set it aside, and the court is convinced and the award is set aside. So what happens? The effect of an award being set aside is it ceases to exist. So it doesn't exist. It's like it never was there, which means that you go back to square zero. Now it is up to you. You want to go back to your contract, you want to invoke arbitration again, you want an appointment of an arbitrator again, it is all up to you. Another scenario that happens, and there is a provision which is called remand in the Arbitration Act. So what the legislature is mindful of is that not every award needs to be set aside fully. Sometimes there are some problems in an award, and you can identify those and send it back to the arbitrator and say that, you know, you can look at this and deal with it. So it's called a remand. So for instance, let us say an arbitrator awarded interest when there was no clause in the, or when there was a clause in the contract which said no interest. So the clause specifically barred interest in the contract, and the arbitrator went ahead and awarded interest. I file a challenge as the party who's aggrieved. I can, in my challenge petition, which goes under 34, invoke 34(4), which says remand, and say that if you consider it appropriate, please send it back to the same tribunal, ask him to relook, and then he can take out this finding. Now, it doesn't happen in all cases, because in this, I as somebody, I mean, a lot of strategy plays out. As somebody who's aggrieved with the award, if the award is not in my favor, if I'm aggrieved with the award, I would want the entire award to go. But the party who got the award in its favor would want to keep the award and just have this wrong bit in the interest bit set aside. So then there are principles whether the award can actually be sent for remand or not, or the entire award has to go. But those are the basic
So we will
principles.
take last question.
So,
Sure.
ma'am, I have a question,
Sorry,
if I may.
yes.
Good afternoon. Ma'am,
Good afternoon.
I wanted to understand the concept and importance of seat of arbitration in a contract and also relevant to the law of the land which is applicable.
It's very unconnected with this. Can I take it in the end
Oh,
if
sure,
that's okay?
sure.
All right. Okay, sure. So appeal process we've covered. The next is
and you arrest him, he becomes an accused. And obviously, after arresting a person, it will not be a situation that you will not be proceeding against him in the criminal court. You will be filing a prosecution complaint, definitely. So, in my opinion, that judgment does not. I mean, for me, it's a per incurium judgment. In my most humble submission. Now, I was talking about that protection against self-incrimination. So, a person who's not an accused, going before the enforcement directorate, deposing against himself, cannot mount this defense. This defense can only be mounted by a person who becomes an accused. Now, at what stage he'll become an accused? For me, when he gets arrested, as per Anubrata Mondal, mere arrest will not make him an accused. Only and only when the prosecution complaint filed by the enforcement directorate before the special court is taken up and the cognizance thereof has been taken. Only then he becomes an accused. So this is a difference. Now, apprehension of arrest on attending summons, which most of your clients would be having, that, what if we get arrested? So there was a writ petition that was filed before the Delhi High Court by one of the petitioner, Ashish Mittal. He said that since I am being called as I don't know the nature, whether I'm called as a witness or as an accused, I'm just being summoned before the enforcement directorate. What if I get arrested? In that case, just provide me some kind of a blanket protection that if I appear before the enforcement directorate, I be not arrested. So that prayer of his was discarded. No relief was given. Delhi High Court categorically said that section 50 and section 19 run altogether different. Merely because you've been called, we don't know whether you've been called as an accused, whether you've been called as a witness, whether or not you will be arrested, we cannot anticipate, we can't grant you any protection. So this is the settled law. Section 50 summon cannot be challenged. You challenge it in a writ petition, the writ petition would be dismissed because no high court would interfere in the investigation process. Section 50 statement is this is the only provision under the PMLA where the statement can be recorded, where the documents can be sought from you, where the direction can be given that pass on such and such information to us. There's no other provision apart from section 52, 50 subsection 2 under PMLA. Apart from this, there's no provision. Yes. Yes, sir. No, sir. 53 is different, sir. 50 subsection 3 talks about the statutory obligation that you have to abide, you have to attend the summon, and then you have also to depose the true facts. You have to depose the truth. 50, generally what happens, the summon would state whether your appearance is required in person or through, if it is required in person, obviously you have to go. It might be a case wherein certain documents are sought. So they say that you bring the documents in person or through an authorized representative. It is only in the context of documents. But if your statement has to be recorded in person, that cannot be done through an authorized representative. Though we came across, when I was in the department, we came across certain petitions being filed, people saying that we are sick and infirm, get our statement recorded through a video conferencing. But the stand of the agency is that there is no provision in the Act enabling your appearance through a VC in any given fact and circumstances. You come, you appear, and it is only through that process that the statement would be recorded. Coming to the next, that is the effect of non-compliance of summons, which I just told you that if you don't abide by the summons, say one summon you don't appear, second summon you don't appear, third summon you don't appear, that will make a potential ground for you to be arrested. They'll say that you are non-cooperative, you are not cooperating with the investigation, that will raise a suspicion. The legal implication would be under section 63 which says that a person who intentionally disobeys the direction to appear before the authority under section 50 is liable to be proceeded against section 174 also. Section 174 is of the erstwhile IPC is where you do not abide by the directions of a public servant. So one is that a separate complaint can be filed against you under section 174 IPC for not appearing before the authority under the PMLA. Secondly, which I just said, that it will give a potent and a very reasonable ground for the department to arrest you. I've gone through many cases wherein we read the grounds of arrest, and it categorically says that the person was summoned thrice, 4 times, 5 times, 11 times, and he did not appear, and he kept on asking for dates on one pretext or the other. He kept on submitting his medical record, and accordingly he evaded the summons. So this is the implication that follows. Another is that you're legally bound to state the truth. If you do not state the truth, there are some implications in the act. You can be penalized for that matter. There's a provision that says just a fine that says 500 rupees for that matter for every default that you make when you do not appear before the agency. So this is the implication in relation to the non-attendance of summons. Coming to the arrest now. Arrest under section 19. I've just highlighted some of the expressions which needs to be perused very thoroughly. I'll read the section. It says, if the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government or by general or special order, which has not been done till so far, and it is only the authorities under the act who are empowered to implement and to implement the PMLA and arrest the person, has on the basis of material in his possession. This expression is very important. Material in his possession, reason to believe, which is to be there in writing. The reason to believe is to the extent that the person is guilty of the offense of money laundering. The expression is so strong, it says you have come to a conclusion that he is guilty of money laundering. It is not an arrest which is preventive in nature. Say there is a preventive arrest in police. A police officer can arrest you, and when he has suspicion that you are going to commit a cognizable offense. So the police has the power to stop you and to take you into custody so that you don't commit a not a criminal offense. But under the PMLA, once the offense of money laundering has been committed and the investigation conducted by the competent investigating officer brings him to a conclusion that the person is guilty of the offense of money laundering, that gives him the unfettered right to invoke the power under section 19. So it is not preventive in nature different from the ordinary criminal law where preventive arrest is also permissible. This arrest is post commission of the offense of money laundering. Under this act, he may be arrested. Now the word may. There was a recent case wherein the argument by the defense was that the expression may would not mean that he has to be arrested. The expression is may and not shall, that he shall be arrested. The argument was that even if you have material in your possession, you have reasons to believe that the person is guilty of money laundering, it is not necessary that in each and every case the arrest should be conducted. It is not necessary that the arrest should be executed because the expression used is may and not shall, which obviously has not been entertained by the court. It says, he may arrest such person and as soon as may be shall inform him about the grounds of arrest. Now this is very important, grounds of arrest. This is a judgment by Honorable Supreme Court Pankaj Bansal versus Union of India in M3M case. The department, when they arrest you, they'll serve you with the grounds of arrest. It will be written, they'll read it in front of you and they'll ask you to sign it, and they'll make you give an endorsement that you have gone through the content and you have read it. Just like we say read over and accepted as correct. So the person who's been arrested, the arrestee, would be served the grounds of arrest, and he'll be signing, he'll be endorsing that I've gone through the content and I am able to understand the content therein, that's why I've been arrested. Now prior to Pankaj Bansal being into picture, which came last year by the Supreme Court, the grounds of arrest were just furnished in a way that you are served with the ground of arrest, you are made to read the content, you sign it, and then the grounds of arrest are taken back and they are maintained in the file of the arresting officer. The grounds were not supplied to the arrestee because there is no provision in the act. Now, Honorable the Apex Court says that insofar as informing him is concerned, the second last highlighted expression, informing him means that you have to supply a written copy to him. Merely by supplying a copy and taking it back with an endorsement that he has read it and accepted it as correct and he has gone through and he has understood the content therein, that why he is being arrested, would not suffice. It is necessary that he should be supplied a copy of grounds of arrest so that he can mount a good defense when it comes to custody. When the department will seek the custody before the special court, it becomes necessary that the person should be having all such documents that led to his arrest, and grounds of arrest being one such fundamental document. Yes. No. There's no lawyer. Yes, sir. How will he keep the? No, so I tell you. So say for example, he is being arrested in the office. He'll be supplied. Then, like I said, there will be an intimation of the arrest. The last point. I was about to come on the intimation of arrest. The intimation would be given to his family members and whosoever he points out, a near friend or any relative, and the documents would be then handed over to them.
But suppose he is called to the office of the ED.
Yes.
There he is called for questioning.
Yes.
After the questioning, he is arrested.
Yes.
So at that time, he will be alone only.
Yes. No, but then at the time when he's produced before the court of law, when the custody would be taken, when the remand proceedings would start, when the remand would be sought, the ED remand would be sought, then definitely he's entitled to give the he's supposed to have the documents with himself. Otherwise, that would be sheer non-compliance of the judgment of Honorable Supreme Court. And he can mount this defense before the before the concerned special court, wherein he's being produced for the purpose of taking his remand, that I have not been supplied a copy of arrest. So that is necessary. He'll be. Even the court will ask whether or not he's been supplied or not. So that would be clarified there. So what are the documents that are furnished? Is the arrest order or the arrest memo. They are generally used interchangeably. Then second is the grounds of arrest. I'll show you the arrest memo. I think I have reproduced it. It's under the form 3. The rules that I earlier referred to, when I was referring to form 5. So this is the arrest order, wherein at the time of executing the arrest order would be passed and would be handed over to the accused, the arrestee. Then there are grounds of arrest. Then there is a Jama Talashi, the personal belongings of the arrestee. He might be having a cell phone, some jewelry that he might be wearing, any kind of ornament or something of that sort, or whatever cash he's carrying in his pocket, or some documents, identity cards or something of that sort. That would be, then an inventory will be created and then that would be handed over to him. And the intimation of arrest, that is very important. That's a very fundamental principle. You've taken someone into custody and then a near relative, a friend of his, somebody at the family has to be informed, whosoever he suggests that such and such person should be informed. This condition is not so? Pardon, sir, I am not able to hear it. Please hand over a mic to sir. No, sir. At the time of arrest, when the arrest is...
Say, as soon as may be possible.
Exactly. I'll come to that. Now, this expression, as soon as may be possible, the grounds of arrest are to be supplied. So, Pankaj Bansal said simply that as soon as may be possible, the grounds of arrest are to be furnished, means a copy of the written grounds of arrest is to be furnished. Then this issue, as sir pointed out, it popped up in another case before the Supreme Court. That is Ram Kishore Arora. Ram Kishore Arora, categorically it's being authored by Honorable Justice Bela Trivedi, and wherein Justice Bela Trivedi has said that the expression as soon as may be means within 24 hours of the time of arrest. He's been arrested at 10 a.m. today, by 10 a.m. tomorrow, within the 24 hours, the grounds of arrest can be furnished to him. But the interpretation, a logical interpretation, or if I have to defend my client in such a case of arrest, I would say that 24 hours would be too late. So for example, 10 a.m. today he's arrested. There's a time period of 24 hours before which he is to be produced before the jurisdictional magistrate for the purpose of taking his ED remand. At that point in time, he has to mount his defense. He has to contest why his arrest is illegal, why he could not have been arrested, or that even if he's arrested, his custodial interrogation is no longer necessary. So for that, he needs that document. That is the intent and the purpose of Honorable the Apex Court in Pankaj Bansal. That a copy of the written grounds of arrest is to be supplied. But when the judgment later on in Ramkishore Arora came, it said that the time period within which the documents or the ground of arrest that can be furnished to the arrestee, the accused, can be within 24 hours from the date of arrest, from the time of arrest, which certainly would be diluting the effect and the ratio of Honorable Apex Court in Pankaj Bansal's case. Because Pankaj Bansal case categorically said that it has to be a written copy and that has to be furnished as soon as possible. Now when we read as soon as possible in the layman's sense, it would mean at the earliest, at the earliest possible point in time. But when the judgment in Ramkishore Arora came, it said that as soon as maybe means within 24 hours. So that, in my humble submission, I differ on that. I think the effect of Ramkishore Arora is, the judgment in Ramkishore Arora has the effect of diluting the cause that was espoused and addressed by Honorable the Apex Court in Pankaj Bansal's case. So this answers your query, sir. Within 24 hours, any time within 24 hours. It can be within 18 hours, any time point in time. But my point is that it should be before the person is produced before the jurisdictional magistrate, wherein his remand is being sought, so that he can mount a defense. That is the only reason why Pankaj Bansal's judgment said that a written copy is to be supplied. A copy of grounds of arrest is to be supplied. The manner of informing the grounds of arrest can't be simply that you read out the content, you make him read the content and then he signs with an endorsement that I have read and understood the content and okay, theek hai, you've arrested me. A copy thereof has to be supplied. This is what Pankaj Bansal said. And according to my opinion, Ramkishore Arora has the effect of diluting what Apex Court has held in Pankaj Bansal's case. Now, there can be a case wherein the detention is without any formal arrest order. The first tool that we discussed was search. Now, ED officers raid your house, your clients are therein, right? The family members of the clients are therein. Dilbag Singh is one such startling example. What happened in this case? The search started, for example, early morning at, say, for example, at 7 a.m. The search proceedings were being conducted till, say, late night, 12 or 11 p.m. After conducting the search, the person got arrested, say at 2 a.m. next day. Now what happens, the department would contest that we executed the formal arrest at 2 a.m. next day, though we started the search proceedings at 6 a.m. previous day, and we continued the search proceedings till 11 p.m. and then after say 3 or 4 hours, we executed the arrest. Dilbag Singh is one such example. The Panchnama, which is being executed after the arrest, after the search proceedings, wherein it is just like a inventory, what all has been, seized, what all has been seized at a particular residential or business premise. The Panchnama categorically stated that we started the search proceeding at such and such time, and we did not allow the residents, the persons in the house, to move. They went to the washrooms and they had their meals after our permission. When the Panchnama was produced before the Punjab Haryana High Court, wherein the arrest was challenged of the applicant, Punjab and Haryana High Court said that since 6 a.m. you are the Panchnama, that they were not allowed to move, and everything that they done, their movement was constrained. They had their meals, they went to the washroom with your permission. That means they were in your deemed custody. Even if there is no arrest order up till 11 p.m. of that day, and the arrest is formally shown next day, 2 a.m., at the midnight 2 a.m., that would not be legal in the sense that there is an illegal detention that commenced right when you started the search proceeding. So mere fact that the arrest order was executed, the person was formally arrested at 2 a.m. next day in the midnight, will not render his arrest legal. It will be an illegal custody since the very beginning, since the very inception that you started the search proceeding. So this is one such case. Same is the issue that happened in Subhash Sharma and Gautam Thapar. However, Subhash Sharma is a case wherein a different view was taken. In Subhash Sharma, the view was taken that no, irrespective of the time of search, irrespective of when or how long the search has lasted, the time of the arrest would only start as and when the arrest order is being served to you, and the time that is noted in the arrest memo. Only then you can be said to be in the formal custody, and not beyond that, not prior to that. Coming to the next slide. Ram Kripal Meena versus Directorate of Enforcement. These are all such judgments wherein, the bail has been granted, wherein Honorable the Apex Court has went to observe that irrespective of howsoever stringent the PMLA may be, howsoever the stringent the twin conditions enshrined in the section 45 subsection 1 may be, bail will still continue to be a rule and jail would still continue to be an exception. The reverse cannot be envisaged for PMLA irrespective of howsoever stringent the conditions may be. Jail cannot be the rule, bail is the rule and jail is the exception. So all these judgments, and the latest one being Manish Sisodia also, bail is the rule, jail is the exception. The object of keeping a person in a judicial custody would be, when the trial would take, say, n number of days, the number of witnesses that have been cited in the prosecution complaint. We have gone through prosecution complaints where there are, say, more than 100 witnesses. Examination of all such prosecution witnesses will take time, then the defense witnesses will come into picture, and then the trial would be concluded. So putting a person in incarceration for such long period was something that was taken as an aggravating factor by the Honorable the Apex Court in all such cases that I've just mentioned. Now, Prem Prakash versus Union of India, this just came recently. It says stringent conditions in PMLA under section 45 is not an absolute bar. I tell you, section 45 is exactly in perimeter to section 37 of the NDPS Act. There is one judgment that I am reminded of by Punjab Haryana High Court, Justice Arvind Sangwan, Honorable Justice Arvind Sangwan, I think now is transferred to Allahabad High Court. He created an analogy between section 45 of PMLA and section 37 of the NDPS while he was granting bail to an accused. He said that despite the contentions raised by the enforcement directorate that he cannot be granted bail, the conditions are so stringent, the twin conditions are not qualified. He said that simply because of the twin conditions that are enshrined in section 45, there is no absolute bar, because under section 37 also the similar provision is there. So when we grant bail under section 37 NDPS, similarly a bail under section 45 can also be granted. Coming to an end, I think I've almost, yeah. I would this is just in relation to my firm, which I've already, briefed you at the very outset of this session. And what I missed is that I can see that we also have a Japanese desk wherein we cater to 120 Japanese clients and all the pre-incorporation and post-incorporation services that we provide. Thank you so much. Yes, sir. Yes, sir.
But in the case of the Kejriwal arrest, it was expenses
Right.
being incurred by his in a five-star hotel in Goa. That
I
was
tell
the
you,
main case.
The proceeds of crime, it is not necessary that you are in possession of proceeds of crime. Not that's only possession. You may be using or you may be assisting in the use. We have 5 categories of the accused under PMLA, which I pointed out. Whoever directly assists, whoever directly or indirectly indulges, whoever is a party, whoever is knowingly assisting. So even if you are not directly dealing with the proceeds of crime in terms of its process, say possession, use, concealment, acquisition or projection as untainted, even if you are assisting someone, even if you are an abettor, you are facilitating it, then also you can be an accused under PMLA.
But the main plea for defense by the Arvind Kejriwal was that no amount was recovered, no undisclosed amount was
Exactly. So that is what I'm saying. If you read the definition under section 3 that I've just made everyone go through, there are 5 categories of the offenders. The third one being whosoever knowingly assists. So he may not be directly indulging in itself in any process relating to the proceeds of crime or the property which is derived out of the proceeds of crime. Even if he is abetting the offense, even if he is assisting someone. Say for example, that is where exactly when they erase chartered accountants as an accused. This is under the third category. They say that you knowingly assisted in the commission of the offense of money laundering. I am reminded of a case. I will not name the case. Obviously because owing to the fact that it is pending trial and till the offense is not proven, everyone is presumed innocent. This case pertained to a chartered accountant, and why he was arraigned as an accused. The reason is the Black Money Act, which came into force in 2015. It gave a window that you disclose your undeclared, undisclosed foreign assets and foreign income. Now there's his client who didn't do it. Now to save his client, in Dubai he created a trust in the name of his client. At that point in time, and I still think and I still believe, which is subject to correction, I think in Dubai trust does not require a registration in UAE. So the trust was created and the property was shown to be belonging to the trust and not to that individual. In that very case, creation of this false document by the concerned chartered accountant made him liable, though he did not deal with the proceed of crime directly. But then he's assisting the main offender to deal with it. That is where the liability pops in.
Thank you. The question we may take, we may start from the back. If any audience in the back, they have any questions regarding to Enforcement Directorate or PMLA.
We can go beyond
Sir,
those topics also
please.
that we discussed.
Mike. So we'll take Q&A for 15 minutes and then we'll move on
हेलो
to arbitration.
Yes, yes, sir.
Yes, Pramod
सबसे
ji.
पहले तो आपका धन्यवाद, आपने पीछे वालों की तरफ निगाह मारी। सर आपने कहा कि 180 डेज के लिए
Yes, sir.
दे कैन सीज योर एसेट्स।
Yes, sir.
So suppose there are some assets, they are required by the accused
Right, sir.
for some function or some necessity.
We
So
understand.
can
sir.
he
Yes,
get
sir.
the pre-release with some additional security provided to them of the equivalent sum?
Sir, Caesar generally would not yield you this kind of a benefit. This kind of an plea would not be entertained, although in a case of an attachment, I tell you, where the property is attached under section 5, which we didn't discuss here in these tools. When a property is being attached under section 5, under the concept of the second limb, which I was discussing under the concept of the equivalent value,
Yeah.
say it is your property which has legitimate source. You have acquired some property by way of inheritance, and that has been attached as an equivalent value of the proceeds of crime that you have dealt with. In that case, we have judicial precedents, we have judgments and orders from Honorable Supreme Court, High Courts, and also from the Appellate Tribunal, wherein by furnishing a bank guarantee or an FDR of the equivalent value, the asset was released. But this has never been done in a case of seizure thus far. Although I understand, even we have some clients, when a search and seizure operation is conducted, all their bank accounts are frozen, everything is frozen, they're not able to pay the fees also. So we understand how glaring the situation becomes, because, and I sympathize with that also, because somebody, the entire business comes to a standstill. All the accounts are frozen. In one of my cases, which I'm dealing on the other side, the agency went on to freeze the current accounts of the agency also. We filed a writ petition before Punjab and Haryana High Court. As a sequel to that, they made a submission before the High Court that today only we'll defreeze the current accounts. So accordingly, we have withdrawn the petition.
So I am thinking of something कि एक ज्वेलरी उसने ली है अपनी बेटी की शादी में देनी, और शादी ड्यू है,
Right,
वो कहते हैं इक्विवेलेंट अमाउंट का आप मुझसे सिक्योरिटी ले लो. So do they have the power to release?
No, actually, they do
with
not
them?
have this power. The only difficulty is that there is no statutory provision. The example that I gave you in respect of the attachment, which is done under section 5 and not under section 17, this is an equitable relief. This is not a statutory relief. So, and that too, it is only permissible in a case where the property is attached by the department by way of a provisional attachment order under the second limb. That is under the concept of alternative attachable property under the value equivalent or the equivalent value. I tell you, for example, I'll give you a very simple example, sir. There is an offense of murder. The murder weapon used therein is the evidence of the offense of murder. Similarly, proceeds of crime in any which form is the evidence of the offense of money laundering. So the stand of the department is that if you allow the substitution of direct proceeds of crime, that would amount to vanishing the evidence that we have in respect of the commission of scheduled offense. In respect of the offense of the money laundering. So generally, it is only the cases where the property is attached under the concept of equivalent value, not the direct POC. Direct POC can never be substituted. And so far as your question is concerned pertaining to seizure, there is no statutory provision to that effect. Beyond 180 days, nothing can be done. Prior to 180 days, nothing can be done. Yes, of course, when you contest your case before the adjudicating authority, there you can make a plea. But till so far as this request of mine, even I raised this logical request, but it was not acceded to.
Thank you.
Thank you, sir. Let's remain at the back. Any other question from people at the back? I'm taking this pillar as the middle. Anyone? Any other question from the back of this pillar? No. Now we can come forward on the left side. Mine left side. Yes.
No, say Caesar generally goes. See, Caesar, there is no specific amount that is required. What is required is quantification. I tell you, quantification is required when it comes to passing of a provisional attachment order, because therein department would categorically say that, say, we quantified the proceeds of crime to the extent of 500 crore, but the attachment that we are doing at this point in time is short of that because we are not able to find more assets. The attachment can be, say, for example, of only 100 crore or 150 crore, given the fact that they are not able to trace the assets, trace the proceeds of crime. So their quantification is necessary. But when it comes to the seizure, at that point in time, because this tool of investigation, search and seizure, this is at the very nascent stage of the investigation. They are yet to quantify. They are yet to investigate. It is all based on suspicion. That is why it is more dangerous.
But sometimes searches are done even after the case is...
There is no time period for search to be conducted. Generally, it is a tool that is used at the very commencement of the investigation, but there is no specific time period. There is no, just say, for example, there is no specific number of provisional attachment orders that can be passed. It can be n number of attachments that can be done in a given case. Similarly, there can be n number of searches that can be conducted in a given case, because the statute does not impose any bar therein. It depends solely the discretion of the agency, and given the facts and the circumstances, if there is reason to believe.
And, what about the money which has been earned upon this attached money?
Exactly, that is fruits of the proceeds of crime. If you have proceeds of crime which you have parked somewhere, say for example, I am in possession of proceeds of crime which I have gained or acquired through commission of a scheduled offence. Now I invest it in some property. So what I have done is I have converted the proceeds of crime into a property. The value of the market value of the property is exaggerating and is escalating day by day. So obviously that is also the fruit of proceeds of crime, and that would also be liable to be attached. And that would fall into the category of direct proceeds of crime, because it is a direct trail that the department would be able to establish. That he received, say, 100 crore was parked and invested in, say, Sri Lanka or, say, for example, Dubai. He invested in property. He made some overseas investments in something of that sort, and that will also qualify to be proceeds of crime, direct proceeds of crime.
Okay, thank you. Vijay ji.
Yeah.
Yes.
I understand the schedule does not include income tax related offences.
Very good, sir.
So
yes,
now, but it includes cheating.
Yes.
While 420 section was there.
Yes.
So, where to draw a line actually? So like
right.
the income tax offences can also be.
Exactly. This is a very good question, and that was also addressed by Honorable the Apex Court in Vijay Madan Lal's case. They said that while conducting any proceeding under PMLA, if the department, say, comes to this search proceeding, and in some house the department gets, say, some cash component, say 80 crores, say for 80 crores is too much, say for example, let's be practical, say for example, let's say 80 lakhs or 1 crore rupees is found cash component. The Honorable the Apex Court said that you have to see whether or not it is a case of an unaccounted money that is to be dealt with by the Income Tax Act, or the money lying therein has some source with the scheduled offence. In case it is derived out of a scheduled offence, then obviously it is liable to be proceeded against under PMLA. But if it is simple case of an unaccounted money, say I may be able to show withdrawals. I may be having, say for example, I have an income, say per month salary of, say 5 lakh per month. I may be withdrawing, say 3 lakh per month, and I may be accumulating it. Over the past, it's just a very hypothetical example, over the past, say 3 years, I've been accumulating 3 lakh per month at my home. And that given accumulated cash component, one fine day when my house, my residential premises are being raided, that cash component is lying therein. But then I'm able to justify that, see, it is an amount which has legitimate source, this has been withdrawn from my bank account and it has come from my salary, right? Now, just because the cash component is lying therein, the department has to see whether or not it is a case of an unaccounted money that has to be looked into by the Income Tax Act, or it is derived out of some scheduled offence. So insofar as the Income Tax Act, since Income Tax Act is not a scheduled offence, there is a case, it's I think Sachin Narayan versus ITO, that pertained to I think the former CM of Karnataka, I suppose. Therein the PMLA proceedings were initiated upon section 120B, that is criminal conspiracy, read with the Income Tax Act. The defense that was mounted by the accused therein was that 120B, okay, it is a scheduled offence, criminal conspiracy, but criminal conspiracy to commit what? An offence under the Income Tax Act. Income Tax Act is the main offence, right? Which is not a scheduled offence. So a conspiracy to commit a non-scheduled offence would not lead to invocation of the proceedings under PMLA, and that was subsequently clarified by Honorable the Apex Court in Pavana Debor's case. Pavana Debor's case and Yash Tuteja's case. Pavana Debor was the first judgment that came that said that the conspiracy should be to commit a scheduled offence. If it is a conspiracy to commit a non-scheduled offence, then in that very case the invocation of PMLA is not there. So that was also followed in Yash Tuteja's case, that section 120B alone cannot be read. And insofar as the Sachin Narayan's case versus proceedings under PMLA were started through a complaint that was filed in which section 120B was also referred. So 120B, the department said that it is an independent offence for us, because when you read the schedule, it is not read with any other provision. It stands independently there. So our proceedings under PMLA are maintainable simply on section 120B, criminal conspiracy. But the argument was that if I commit a non-scheduled offence, PMLA cannot be invoked. But if I commit a conspiracy to commit a non-scheduled offence, then bringing PMLA into picture would be a clear misuse and gross abuse of the process of law.
Sorry, just a quick follow-up on that.
Yes, sir.
So I'm not on that. My question is on the routine claims of deductions, of allowances, and where it is the intention is clear.
Right.
The forged bills are there, and which are proved without doubt on that case. So are these not cheatings?
Right.
So if these are cheatings, these are covered under the schedule offence. So should such additions on the conclusion that these are misrepresented or cheating should not automatically trigger PMLA?
No, they are being treated. There are various cases. Say, I tell you, there is a sand mining case for that example. Sand mining, the offence is punishable under section 21 of the Mines and Minerals Act 1957. Now, Mines and Minerals Act section 21 Mines and Minerals Act 1957 is not a scheduled offence. So the case of the agency is, in one of the cases which I won't be mentioning because it's sub judice, that the person has committed the offence of sand mining and has reported the outcome, has undervalued the outcome, has underreported the outcome of the mining, and has accordingly committed the offence of cheating by cheating the government exchequer under 420. But when you see the fulcrum of that proceed of crime, which apparently is coming, that is through the non-scheduled offence. What I am doing is not relatable to the scheduled offence. The proceeds are coming from a non-scheduled offence, that is from the Mining Act. Now, Mining Act not being a scheduled offence, the argument from the other side is, from the defense side is, that it is not a scheduled offence. Whatsoever has come to my possession is only out of that mining case and the act of mining, which is not a scheduled offence. That being not a scheduled offence, the invocation of PMLA cannot be brought in just by invocation of section 420 to that extent. Because there may be cases, say for example in Mines Act also, the person can be fined, there are challans and it is a compoundable one. So as such, for example, for that, the offence of cheating would no longer survive. So the stand of the department would go in that very case.
So we can go back, Mohit. Yeah. थोड़ा जल्दी चलो यार आप.
Thank you, sir, for such an insightful session. मेरा एक hypothetically situation लेके एक question था. Let's say आज से 5 साल बाद something happened that I may be arrested for the PMLA. PMLA कितना stringent है? Will there be a froze? मेरी property को आपने क्या word use करे? Freeze कर दिया जाएगा bank accounts को?
Freezing of the bank accounts.
Yes. Yeah. Movable and immovable properties को
seize
कर दिया जाएगा.
Right.
what's about the position and the goodwill I earned during the last 10 years, which might
just sorry to interrupt, just technically correcting it.
Yeah.
The movable, immovable property will not be, the immovable property cannot be seized. The documents, the title deed can be seized.
Yes.
Immovable property cannot be seized. It will be attached. It can be attached, not seized. Yes.
Okay.
Coming to your
In
question.
the current scenario, there are lots of membership offered in the market about the clubs and golf club and so and so.
Got it.
And they use the proceed from the crime to take this membership,
Right.
earn educational qualification,
Right.
earn goodwill, where even though I am arrested, but there are people in the market who are still ready to invest in my mind and in my innovation.
Right.
Right? Arrest के बाद फिर even they are also ready to even invest in because I earned goodwill. तो PMLA कितना stringent है? Till the time or after time also. Till the time जब खुलासा होता है कि PMLA में मिस्टर सो एंड सो को अरेस्ट किया जाता है तो वहाँ तक का ही है या उसके बाद पता लगता है कि गुडविल जो जनरेटेड है उसको भी ईडी जो है वो फ्रीज एंड सीज कर सकती है. Because India is in the era of the startup, ये valuation, वो valuation, innovations, degrees, club membership, which may be religious one and all.
The question is on the jurisdiction of PMLA.
The jurisdiction of PMLA in terms of like what I'm not able to understand. Can you just...
So basically, let me put in this way. You said if there is a PMLA, there is a proceeds from crime which I have put in the bank account and I'm earning interest.
Right.
That can be seized.
Yeah, right.
Correct.
Right.
But now let's say if that money is invested in some intangible asset.
Right.
And that intangible asset got generated.
Right.
I invested that money in R&D.
Right.
Now I've got a patent registered on my name.
Right.
Now if the income is getting generated through the patent,
Right.
whether that is also covered under PMLA, this is the question.
You see the definition of property under 21V, it is so wide. It says property of any kind, corporeal, incorporeal, tangible. It includes intangible also. Even that can be proceeded against.
Till what? Till the time, let's say, arrest happened in 1st January 2025.
No, it is not that. It's not like
या
that.
उसके बाद
No, it's not like that. It's not like that, that it has something to... Achha, so you're on the quantum thing.
Yes.
See, quantum and arrest has nothing to do with it. Say the offense has been committed, right? The offense of money laundering has been committed. Now, it is because of that, the way I was explaining it, that the arrest under PML is not preventive, right? It is already, the offense has been committed. They have already quantified it, right? The further investigation might continue just to see wherever you have invested those proceeds of crime, can they also be traced and can they also be brought within the purview of the attachment or whatsoever the proceeding may be. So the point of determination in terms of when exactly the quantification will stop, that will depend upon case to case basis. I mean, a simple compartmentalization cannot be done. Say arrest, simply a person's arrest would not be a factor to determine whether that is the ending point, because see, it might so happen that the arrest might be, say for example, they've quantified it to the extent of say 200 crores. Now it might be after your arrest, you might make some revelations, right? You might make some revelations and you might give some lead to the agency. You might reveal about some other properties that you have invested in, or through other channels, or through some entities of which you stand as a beneficial owner, of which the agency was never aware of. So it may go, the agency may go against that also. So in that very case, the arrest, the point in time when you got arrested, that doesn't mean that the quantification can be done only till that point in time.
5 second का question, sir.
Yes.
So Rahul, we can discuss outside, please. Now on my right side, if there is any question, yeah, please. ये माइक आ रहा है आपके पास एक बार.
Is there any information sharing memorandum between ED and the Income Tax Department?
There is a statutory provision enabling the Enforcement Directorate to have that interagency coordination. That is under Section 66, subsection 2. They can communicate to the concerned law enforcement agency. That is where this example which Sir just talked about, that they found a cash component lying at your house. So if it is a glaring case of say unaccounted money, so they'll refer it to the Income Tax Department that you take up the investigation. That way. There are searches which are being conducted under FEMA, and there are seizures which are done under FEMA. But in that very case, if in the investigation being conducted under the FEMA by the Enforcement Directorate, it comes up that there's no regulation that has been contravened pertaining to FEMA. In that very case, they'll refer the case to FEMA, the Income Tax Department.
Please.
Yeah, Mr. Sood.
Yes.
A search has been conducted to a person.
Yes.
And they found that that person is also a partner, director, whatever Kalta is.
Right.
And other entities also. So whether they issue that freezing of that bank account or demat account out that other entities also, or out to that particular person itself?
No. That depends from case to case basis. Just because a person is director in an entity, director is an employee of the entity. So that way, it depends in which capacity he is being proceeded against.
Personal
It is personal capacity. Then the agency will have the entity has nothing to do with it. It's a separate corporate legal entity, juristic person. It has nothing to do with that. But in case, say a person is a promoter director, is a promoter and has infused the say initial capital, and then there is some siphoning that has been done through the entity, and the amounts have been routed through the entity.
That has been basically channelized, and then that can travel.
Then in that case,
but
yes.
There is no relation with that entity.
No. Then altogether it can't be done. It can't be done.
So let's have a big round of applause for Anirudh Sudji. Thank you.
Thank you so much for giving me the opportunity to address such a large gathering of luminaries who are expert in their field. And thank you so much, sir, for inviting me to address the audience. And thank you for all the insightful questions that you have asked, so that in case I have missed out on something where it was not possible to elucidate on all the aspects of PMLA. And I think I've been able to shed some light through the question and answer round, apart from what we dealt with in the deliberation that I had through my PPTs. Thank you so much once again. Thank you so much. Thank you, sir.
Thank you so much, Anirudh sir, for such an informative session on the intricate mechanism of investigation. Now, I would request our immediate past chairman Gaurav sir to present the memento to Mr. Anirudh Sood as a token of appreciation from NARC of ICAI.
Thank you so much, sir. Thank you so much for the opportunity.
Next, we are privileged to have Advocate Renu Gupta ma'am. Ma'am, I welcome Renu Gupta ma'am. Please join the dais. Now I request again Mr. CA Gaurav Garg sir to present the live plant to Advocate Renu Gupta ma'am as a welcome gesture. Big round of applause, please. Advocate Renu Gupta ma'am will speak on arbitration, an important aspect of dispute resolution. So let me have a brief profile. Advocate Renu Gupta is a seasoned dispute lawyer with over 17 years of experience and is a co-founding partner of Olive Law, a boutique disputes firm. She advises clients on transaction strategies to avoid disputes and represent them in courts and arbitral tribunals, also serving as an arbitrator. She holds a BSL LLB from Symbiosis Law School and LLM in International Business Law from the London School of Economics. She began her career at economic laws practice and later established her independent practice in Delhi. Passionate about education, she also conducts various workshops and serves as a visiting faculty member at various law colleges. She is also a member of several professional organizations, including Young ICCA, and holds memberships in multiple arbitration panels. Now I request Madam Renu Gupta to please start her session.
Good afternoon, everyone. I'm usually very loud, so I don't use mics, but okay. I hope this is audible to everybody.
You may be louder.
Okay, all right. Good afternoon. So I think Gaurav ji contacted me, and the idea of my presentation is to introduce the concept and topic of arbitration to a room full of chartered accountants, and focus then on areas where chartered accountants can see themselves as participating in arbitration proceedings. And just like engineers, technical members, experts on valuations today, I think we are seeing increasing interest from chartered accountants in the arbitration proceedings that go on. So I thought I will talk about that. So very quickly, I'm assuming a lot of you will know basics and the concept of an arbitration, but very quickly, what is an arbitration? Arbitration, or what is an arbitration agreement? How does it happen? It's effectively a private dispute resolution, so you don't go to court for it, you're outside court. But how does it arise? It arises from a contract. It cannot arise without a contract, and I think that is the most important starting point for it, that two parties need to agree that we are going to have an arbitration and we are not going to go to court. So that's why the starting point is that it's a private dispute resolution process. Typically now, how it starts is that, and how it started is that it became a mode for settling commercial disputes. We have as a subject matter several things which you cannot arbitrate. So you can't take your family disputes to arbitration. You can take them to mediation. You can't take them to arbitration. There is controversy still on what parts of insolvency winding up can go to arbitration and what part cannot. Most of it cannot, but there are some parts of the contractual commercial dispute within the insolvency process which can. Issues like fraud, I think courts have struggled for several years. Now again, there are decisions of the Supreme Court which say that if something goes to the root of the matter and it's a fraud, unlike the old view where only courts were going to look at it, the arbitration as a private forum mechanism, they're going to. So over the last 50, 60 years, the scope of arbitration has been increasing, and as a consequence, the scope of disputes which are getting decided in courts is narrowing within that space. So more and more parties are taking their commercial disputes to arbitration instead of courts, and we'll see why that is happening as well. So that's a quick sort of a slide on major differences between arbitration and litigation. One key advantage that parties see is that everything is confidential. Now, the degree of confidentiality in a country like India still at a practical level is questionable, but as a concept outside India, the confidentiality is the key, and it's taken to a very serious level, including the fact that lawyers don't even disclose the names of the parties that they represent in an arbitration unless the award subsequently lands up in a court dispute and then the names, become public. So that's the degree of confidentiality that attaches to high value commercial disputes. Companies don't want to sort of tell everybody that we've had a dispute. A large part of it, yes, gets published in their annual reports if these are listed entities, but there are sort of certain provisions by which they can, they can assert some degree of confidentiality even on that ground. Cost, at a practical level, I think that concept is changing. Initially, to start with, arbitration was seen to be cheaper than courts, and that is why parties were being pushed to do more of arbitrations, because a matter in court which was taking a commercial suit in Delhi High Court, if something is more than 2 crores, so you can go to Delhi High Court if something is more than 2 crores in terms of Commercial Courts Act of 2050, it would take anywhere between 7 to a 20-year, and in some cases, the lawyers and the system could just drag it on for more than that as well. But I think things on that front are changing, which is why on the speed aspect, while the concept was that this will cost you less, I don't think practically it has played out as that. Arbitrations today are very expensive. Timeline, yes, is a certain benefit. Under the Act today, you have the tribunal has to complete the pleadings between the parties within 6 months, then you get 12 months, then 6 months extension only with consent of parties, and another 6 months only if you go to court. So by and large, the default time period that you have in an arbitration is 6 months of pleadings plus 12 months plus 6, and plus 6 you go to court, but that's a 2-year horizon over which you see a matter getting concluded. Yes, please. But those will be all under the older version. So this time limit concept has come in only in 2015. 2015. It depends. So, okay, so I'll answer that question clearly. So, there is a provision in the Arbitration Act 29A. For the first time, the legislature introduced this provision to introduce timelines. Now, it came in 2015, and then this entire controversy started that will it apply to pending cases, will it apply to pending arbitration, court proceedings, and the court then effectively settled this saying, I think the date is 23rd October 2015, that if your notice of arbitration is prior to 2015, so the dispute that you're talking about is 2018, possibly the notice of arbitration in that was given prior to 23rd October 2015, which is, then I don't know what the team is doing, yes. It should not. So, I mean, I cannot advise, but I mean, if you're involved and if you want to sort of ask people questions, you must, which is that if the timeline is 6 plus 12 plus 6 plus 6, possibly the mandate of the tribunal has also expired if you have not applied for an extension of time. Possibly. There is a provision, you can go to court, like you can go, so let's say it doesn't finish in 24 months, you can still make an application and tell the court that the tribunal is asking for 3 months more time to write an award or 4 months more time. But if you're saying you're sitting from 18 to 24 and it's been 6 years and this is post 2015, there is a problem which somebody needs to identify and solve is what I can say. Yes, sir.
And they have taken the fees beforehand, at the time of start of the arbitration cases. Don't you think it was their responsibility to tell the parties that their tenure has stopped and they must deliver the judgment?
Sir,
they have not delivered the judgment, then what was the use of starting the arbitration?
I think that's slightly digressing. I don't want to give a view on what somebody should have done, should have said, but
Sir, let's understand the law. Why your case is pending, when the law is clear, now you know the law, I think you can speak with the client that the order
I think it's important to be.
Sir, she cannot advise on a personal issue. Sir, we need to understand that is a very specific issue. Until as you bring the file and discuss each and every aspect.
I mean, you'll have to reach out to a lawyer and maybe get a second opinion from somebody else is what I would suggest. So the timeline is covered, and then we have the appeal process. This is also a very distinguishing feature between courts and arbitration. So in courts, what you have is appeal. So you get a decree, you have a first appeal, in certain cases you have a second appeal, and you have avenues right up to the Supreme Court. What is important to know is the scope of that appeal. In a court matter, the scope of the appeal is very wide, which is that anything that that a lower court does wrong, the superior court, while the matter comes in an appeal, can undo and look at. This is something the legislature, and I mean not the Indian legislature, our law is modeled on the UN Citral model. This is where they introduced a limited scope of challenge. So it's not an appeal procedure. An award, once it comes from an arbitrator, is binding. And the legislature then gives you very limited grounds of challenging that award, because they don't want this to become a parallel to an appeal, that you get an award and then you treat it as a court decree and you continue to do 5 rounds of litigation and exhaust the parties. So today, if you have an award, there are very limited grounds. The provision is section 34 of the Arbitration Act. The nature of the grounds basically is that if something is extremely wrong, extremely perverse, you can't say that the arbitrator interpreted the contract in this manner while it should have been in the other manner. which is, so the settled law is that if there are two views possible and the arbitrator has taken one view, it's okay, we are not going to interfere. If there is something which is on evidence, we will not interfere because the arbitrator is the master of the evidence. If there is something on first principles of law, you will have to demonstrate to court that there is something which is fundamentally wrong with law. So for instance, let us say the arbitrator says this is a contract, and you say that the evidence never showed that there was any contract between the parties. So that is something which fundamentally the arbitrator got wrong, and the concept and the word they use is called perversity. So you have to find perversity in an award which the courts say should shock our conscience, and only then we will consider interfering with an award, because the mandate of the law is that you have chosen Mr., Miss X, Y, Z to decide your dispute, and too bad if they got it wrong a little. We are not going to get into it. Yes.
Initiate an allegation of bias, so and then prolong the process again.
It's not so easy, because the statute has provided very defined contours of what is bias, what are grounds of bias, at what stage you bring it in. The detailed schedule, Schedule 5, Schedule 7, one schedule if you fall in any of the entries. For example, if an arbitrator, so there are two lawyers, there's one arbitrator, two parties, and for one of the parties, the arbitrator is acting as a consultant or an advisor. It's an entry in the schedule which bars him, and he's automatically disqualified, which means as a party, you know, the other party, you know that he's disqualified, you can raise that ground, he'll be out of the scene. If you don't raise it, assume you don't raise it, you are either ignorant or you don't know, whenever this award goes to court, the award will be set aside for the asking, because the arbitrator from day one was disqualified under the law.
So when you say it goes to court and it sets aside, so is it that the court gives a direction that again the arbitrator is to be appointed?
No, so that's a good question. Typically in a case.
Right, sorry. The question was, when because of any reason like bias we talked about, the court decides that there was a bias and the award is set aside. So what happens next?
Yes,
so whether court takes it over from there or directs another independent arbitrator to be appointed in the opinion of the court?
Correct. So a couple of options as they play out. I mean, forget the ground of bias. On any other ground, let us say you have a good award, the party challenging is able to make out a ground that there was no evidence in this case for this claim which the arbitrator has awarded. Please set it aside, and the court is convinced and the award is set aside. So what happens? The effect of an award being set aside is it ceases to exist. So it doesn't exist. It's like it never was there, which means that you go back to square zero. Now it is up to you. You want to go back to your contract, you want to invoke arbitration again, you want an appointment of an arbitrator again, it is all up to you. Another scenario that happens, and there is a provision which is called remand in the Arbitration Act. So what the legislature is mindful of is that not every award needs to be set aside fully. Sometimes there are some problems in an award, and you can identify those and send it back to the arbitrator and say that, you know, you can look at this and deal with it. So it's called a remand. So for instance, let us say an arbitrator awarded interest when there was no clause in the, or when there was a clause in the contract which said no interest. So the clause specifically barred interest in the contract, and the arbitrator went ahead and awarded interest. I file a challenge as the party who is aggrieved. I can, in my challenge petition, which goes under 34, invoke 34(4), which says remand, and say that if you consider it appropriate, please send it back to the same tribunal, ask him to relook, and then he can take out this finding. Now, it doesn't happen in all cases, because in this, as somebody, I mean, a lot of strategy plays out. As somebody who's aggrieved with the award, if the award is not in my favor, if I'm aggrieved with the award, I would want the entire award to go. But the party who got the award in its favor would want to keep the award and just have this wrong bit in the interest bit set aside. So then there are principles whether the award can actually be sent for remand or not, or the entire award has to go. But those are the basic principles.
Last question.
So,
Sure.
ma'am, I have a question,
Sorry,
if I may.
yes.
Good afternoon. Ma'am, I wanted to understand the concept and importance of seat of arbitration in a contract, and also relevant to the law of the land which is applicable.
It's very unconnected with this. Can I take it in the end
Oh,
if
sure,
that's okay?
sure.
All right. Okay, sure. So appeal process, parties deciding we're going to go to arbitration. Parties can choose who their arbitrator can be, parties can choose what law they want to go to, parties can choose a venue, parties can choose what rules of evidence will apply. They can say none of us will file original documents. They can say we will do only documents based arbitration, no oral evidence will be introduced, which is why there is a concept of party autonomy wherein there is no party autonomy in litigation. You have, if it's a commercial civil dispute, you have CPC, Civil Procedure Code, which tells you this is the procedure and you have to follow that procedure by the book. And enforceability. So unlike decree in a civil commercial suit from a court, you can enforce those decrees in reciprocating territories outside India where India has signed up some conventions, but for an arbitral award, because of New York Convention, you practically get any and every decent jurisdiction and country in the world where if you can find that the person who has to pay you money has assets, you can go to that country and file an enforcement and an execution proceeding there. I'll give you examples, which were very public. When Air India, I think, was being sued. So Air India, there were some foreign companies which were suing Air India for the money that they owed under arbitral awards, and they went to Paris and so many other places and they got assets attached because Air India had assets in like several countries. So that was just an example to show how you can catch assets of the judgment debtor anywhere that they have assets.
But in that case,
Yes.
that was an American person. He got the assets of the Air India tax.
Yeah, so I'm not saying it was an Indian award. I'm saying somebody got a foreign award and then assets you can find anywhere. So again, I'll simplify the example. Let us say company A, company B. They have a dispute. They do the entire arbitration in India. Company A, company B, both Indian, but company A has some land, some immovable properties, some bank accounts abroad, and the award is against company A and you have to recover money from company A. So normally you would think of filing an enforcement only in India for that award, but in an arbitration you can actually go anywhere that that company has assets. So and the benefit would be in most advanced jurisdictions the enforcement process will play out faster, more efficiently. There will be less hurdles to eventually getting the money in your pocket.
But it will apply only for those countries which have signed a convention.
Yes, yes. But by and large, most civilized nations have signed the New York Convention.
But there are 200 plus, and this convention has not been signed by even 50, 60.
No, I agree, but that's why I'm saying most civilized nations, they've signed it. I can't remember the list which has not signed, but yes, if the assets happen to be in a country which has not signed the New York Convention, you will not be able to take the benefit of enforcing it in that.
A similar case in the case of the enforceability at the courts. There are the bilateral and the multilateral.
There is. But the countries who have signed the New York Convention are much more in number as opposed to India having signed those bilateral reciprocating conventions with countries saying that, if my people want to enforce decrees in your court, they can do it, and if your people want to do it in my courts, they can do it. So just a comparison in that sense.
Can you please go to the previous slide?
Yes.
So the last point on this, so generally actually we, when we enter into cross-border
Yes.
engagements or professional engagements, so normally the client is in a better negotiating position. So they have a standard clause that this will be subject to the jurisdiction of the overseas country on that. So which is always a scaring thing for us actually to do. So in that situation, is it a good alternative to have an arbitration clause provided the arbitration clause gives me enough scope that the arbitrator can be from anywhere?
So now, because this is a cross-border contract, so whether it will be possible in case of a dispute to say that I'll prefer have an arbitrator in India in that case.
Okay, so I mean, you've asked a couple of questions within this question, but coming back to the party autonomy point, by and large, you can say, I only want a chart. Parties have agreed that we will only have chartered accountants as arbitrators. Parties have agreed we will only have engineers as arbitrators. There is nothing which stops you from doing that. That's one part. The other part of your question is whoever has a higher bargaining power will eventually decide which jurisdiction, which courts, which arbitral institution and where to go to. I think there is, I mean, in large contracts, I mean, I do a lot of construction infrastructure contracts. Unless those contracts are with Indian PSUs where, you know, so a foreign vendor and an Indian PSU, the Indian PSU always insists and gets it as Indian law, you know, seat is Delhi or Bombay, Indian law will apply. But there have been, I mean, I think I have seen in equal number of cases where there is an Indian PSU which has done a foreign vendor, an offshore contract, and the seat is Singapore. ICC rules of arbitration. I think they all, it's a part of a larger strategy to figure out where the assets are going to be, which courts are going to be better in terms of enforcing, and a lot of other considerations which go into how you're going to draft your jurisdiction and arbitration clauses.
So now we will proceed for 15 minutes and then we will take.
Okay, okay, all right, okay. So this is, I mean, just a primer on what constitutes an arbitration agreement. So it's an agreement. Courts have gone to the extent that it need not even be in writing. So you can sort of, you know, if with evidence you can prove that two people agreed on a phone call that we're going to arbitrate a dispute, the arbitration agreement must be in writing. An agreement will be deemed to be in writing if it is contained documents signed by parties, exchange of letters, telex, telegrams, telecommunications, allegations of agreement made by one party not denied by the other. Parties agree to refer present or future disputes. The arbitrator is empowered to adjudicate and yes, the rest. One important thing to which I want to mention at this stage is a lot of litigation happens. So either your clause in the contract will say sole arbitrator or it will say a 3-member tribunal. Now a lot of times I'll step back. So before, I think this is 2018 or 19, there is a judgment of the Supreme Court, Eastman Perkins. Before that, you would have all seen that PSUs were always appointing their own retired people as arbitrators. So that is something which stopped having post this judgment, that you cannot have in sole arbitrator. So you cannot have a sole arbitrator who in a contract between two parties is a nominee of one party. So as a result of that, that sort of side of appointment of arbitrators, and I think if I recollect, I saw this in a couple of contracts where one party was also appointing its own chartered accountants and technical members as arbitrators. So all of those things are now over. We are in a era where unilateral appointments are not considered okay. If at all there is and parties go through an arbitration, the award whenever it goes to court is worth 0 and it's worth like nothing written on the paper. Today, when parties don't agree on who the arbitrator should be, or let us say you appoint your nominee, the other party appoints their nominee, and a presiding arbitrator is not appointed, what happens as a consequence is you end up in court for the appointment of an arbitrator. It's under Section 11 of the Arbitration Act, and again this law evolved over I think 20 years, but today the position is that when you go to court for an appointment, the court is only and only going to see whether there is an arbitration agreement or not. They're not interested in going into the merits of the case. They're not interested in going into payments, etc. The only thing that the court wants to see is whether an arbitration agreement exists or not. If it does, they say that you take everything before the tribunal and we are not interested in dealing with this anymore. This slide, so now we are moving on to the domain of appointment of arbitrators. As a procedure, I think the gentleman here asked me that the arbitration started in 2018 and I said notice of arbitration. So commencement of an arbitration is always from the notice of arbitration. So one party writes to the other and says that I have disputes, you've not paid me, and here my notice for arbitration. That is the commencement date of arbitration. The relevance of it comes for the purposes of limitation. So let us say you give a notice of arbitration in 2020 and your claims are, let us say, falling within 3 years backwards from 2020, so 17 to 20, and then you don't do anything until 2025 to go to court. So those are situations in which limitation can become a problem. Even number of arbitrators is something which is not permissible, so it always will be odd, it will be 1 or 3. Parties can even agree to the procedure for appointment. So I think again the gentleman in front asked me, can I say the Indian arbitrator? So arbitrator can be any nationality. There is no restriction that it should be the nationality of either the parties, or it should not be the nationality of the parties, because they think that, you know, if it's an Indian party or let us say a Malaysian vendor, the arbitrator of the Indian party should not be Indian and the Malaysian vendor should not be a Malaysian. But in contract, you can provide for it. So if you were to provide a clause in the contract which said that the arbitrators to be nominated by the parties will be of neutral nationality, that would mean that you will not be able to make a nominee arbitrator who's of the same nationality as the party. I think I have covered this. I will come to that. I will come to that. When you say okay, I see what you're asking. You're saying if it basically becomes less than the period which the Act provides. Is that what you're asking me? Because there's a period. It can, but I think there is a view which the courts have taken that you cannot reduce the statutory period which is provided. So if the Act provides 6 plus 12 plus 6 plus 6 and the parties agree that the award must come in 6 months from the date of notice of arbitration, the one view that the courts have taken is that this is in contravention of the statutory mandate which you cannot do. So you're reducing the period which is available to the parties and that you may not be able to do.
So that the other contracts can be executed on time. That is why these kind of things do happen, because small things go for arbitrations.
Sorry, I didn't follow your question. What is the scenario in which they will specify a small
larger
time
contract, a part of those contracts may go for arbitration.
Yes.
But the entire contract may remain valid.
Yes.
So for execution of the larger contract, those small contracts may have a limited time period.
Actually no, because those contracts have specific clauses that during the pendency of the arbitration, both parties have to continue to perform their obligations. Unless one party gets some injunctive relief and there is a restraint on continuing with the work, the project continues and you have only brought a limited part of the dispute to arbitration. I have, in my experience, I have never seen that as a reason for expediting because I want to continue with the works. So it's like saying, for instance, in a construction contract, your prolongation cost is increasing. So what you want to do is you want to put in your claim for prolongation because you don't want to face limitation issues. You put in your claim for prolongation and then you continue to work on. And in fact, you kind of put more claims. So you aggregate it over 6-month or quarterly periods. The contract usually defines it and you submit those claims to the arbitrator. This is the Perkins judgment 2019 where the court said that sole arbitrator's unilateral appointment is no longer good. the only exception. Parties may waive this restriction by way of a written agreement with the parties. So they can waive it post-constitution with consent. Conduct of arbitration proceedings. This again, some part of it is in the realm of party autonomy and the other is on what rules are available in the Act around conducting the proceedings. The rules governing arbitration, if you see, parties can agree. These are all institutional rules. LCIA, which is London Court of International Arbitration. DIAC, it stands for Dubai International also, or Delhi International also. SIAC, Singapore Arbitration, International Arbitration. MCIA is Mumbai. In India, we have, I think, more than 100 institutions which conduct arbitration. So parties do choose to have any of those. Failing any agreement, the benefit of these institutions is that they have a certain set of rules which tell you that, okay, you are supposed to do this, you know, as per this, this is going to be the cost, this is how much you have to pay arbitrators, this is how you submit documents. In the absence of that, the parties with the arbitrator kind of agree and a procedural order is passed where procedural directions are given that you will file everything by email, give hard copies, comply within X days, etc. So those are... no, it applies to... So that's the second bullet, which is, so two kinds of arbitration, ad hoc or institutional. Ad hoc, you can have a sole arbitrator also or a 3-member tribunal also. If the parties have not agreed to apply any institutional rules, then the tribunal will decide. Tribunal will decide with parties' agreement what they... So either you could specify it in your agreement already that parties have decided they will provide 30 days to each other for doing this. Parties will, I mean they can, there are clauses where you can provide 5-10 things in your agreement. If you don't, then the tribunal along with the parties at the first hearing passes procedural directions which are similar to what the institutional rules provide. But then you have the flexibility of what the tribunal and parties are agreeing. I mean, the rules might say party has to file a statement of claim in 30 days and a defense in next 2 weeks. But when the arbitrator and the parties are mutually agreeing and setting out the procedure, those timelines can be varied because there are no timelines to follow by the book except the larger 6-month, 12-month, 6 and 6. The third bullet is very interesting, and again that is a distinguishing feature between institutional rules and ad hoc arbitration. The Arbitration Act says that the tribunal is not bound by strict principles of CPC and Evidence Act. This does become a little controversial at some points because questions for, and this becomes controversial more in ad hoc arbitrations. To give you an example, the Evidence Act, for instance, says the best evidence rule is original documents. Best evidence, as we call it, is that a party has to file original documents. Now, the tribunal is not bound by the evidence. The parties go ahead and file photocopies of documents. The question arises whether that rule in the Evidence Act is a fundamental principle of Indian law or not. Because if it is, and it is not followed, then that might be a ground available to challenge the award. Which is why the rules of procedure become very important for the parties to know upfront, you know, what rules am I following, so that there's no sort of a foul play at the end where maybe they proceeded on photocopies as a matter of course in arbitration, but the party who loses eventually will take every technical argument available to frustrate and defeat the award. So that, I think that this slide is about that. So the Arbitration Act does not provide, and there's a reason why it does not provide that, because it says party autonomy. Parties are free to decide any procedure that they want. There are some broad parameters which the statute provides, broader timelines. What is bias, grounds of bias, when will an arbitrator be disqualified. There is a schedule of fee also which is provided for the arbitrator, that if the dispute value is between 1 CR to 10 CR, this will be the arbitrator fee, etc. All of those things are provided, but beyond that, it leaves it to the parties to decide. Now, because of the party autonomy principle, parties can decide this in a couple of ways. One is, you say that I want to be governed by X rules of arbitration, which can be, for instance, let us say in Delhi International Arbitration Center rules. Those rules then bring in some certainty, and they will say that, okay, parties have to file only photocopies, no originals are needed. But if you don't, and in India, majority of arbitration domestic is still ad hoc and not institutional, which means that you don't have any rules which say original or photocopies. So there is no standard operating procedure, because the tribunals are diverse, and you can't give tribunals a standard operating procedure because these are private tribunals. Unlike a court where you can standardize and say, the High Court can issue directions to the entire lower judiciary and say, this is what you will follow in a certain thing. Supreme Court can issue instructions to the High Court and say, this is what all of you in the country will follow. There cannot be, except the statutory mandate or a mandate which comes from the rules, the tribunal's contours are the arbitration agreement. And if nothing is provided in the agreement, the fallback, which in a court always, in a certain procedure, in a certain definite system, is always distinguishing feature between institutional rules and ad hoc arbitration. The Arbitration Act says that the tribunal is not bound by strict principles of CPC and Evidence Act. This does become a little controversial at some points, because questions for, and this becomes controversial more in ad hoc arbitrations. To give you an example, the Evidence Act, for instance, says the best evidence rule is original documents. Best evidence, as we call it, is that a party has to file original documents. Now, the tribunal is not bound by the evidence. The parties go ahead and file photocopies of documents. The question arises whether that rule in the Evidence Act is a fundamental principle of Indian law or not. Because if it is, and it is not followed, then that might be a ground available to challenge the award. Which is why the rules of procedure become very important for the parties to know upfront, what rules am I following, so that there's no sort of a foul play at the end where maybe they proceeded on photocopies as a matter of course in arbitration, but the party who loses eventually will take every technical argument available to frustrate and defeat the award. So that, I think that this slide is about that. So the Arbitration Act does not provide, and there's a reason why it does not provide that, because it says party autonomy. Parties are free to decide any procedure that they want. There are some broad parameters which the statute provides, broader timelines. What is bias, grounds of bias, when will an arbitrator be disqualified. There is a schedule of fee also which is provided for the arbitrator, that if the dispute value is between 1 CR to 10 CR, this will be the arbitrator fee, etc. All of those things are provided, but beyond that, it leaves it to the parties to decide. Now, because of the party autonomy principle, parties can decide this in a couple of ways. One is, you say that I want to be governed by X rules of arbitration, which can be, for instance, let us say in Delhi International Arbitration Center rules. Those rules then bring in some certainty, and they will say that, okay, parties have to file only photocopies, no originals are needed. But if you don't, and in India, majority of arbitration domestic is still ad hoc and not institutional, which means that you don't have any rules which say original or photocopies. So there is no standard operating procedure, because the tribunals are diverse, and you can't give tribunals a standard operating procedure because these are private tribunals. Unlike a court where you can standardize and say, the High Court can issue directions to the entire lower judiciary and say, this is what you will follow in a certain thing. Supreme Court can issue instructions to the High Court and say, this is what all of you in the country will follow. There cannot be, except the statutory mandate or a mandate which comes from the rules, the tribunal's contours are the arbitration agreement. And if nothing is provided in the agreement, the fallback, which in a court always, in a certain procedure, in a certain definite system is always. On the technical side, it's very good because you don't have to labor too much trying to explain them how a road is built, how a bridge is built, and this is the problem, you know, what happened. But on this side, they do struggle because it's not sort of available as a structured rule book, is how I would say it. The institutions have it, but on the ad hoc side, it's not there. As the only institutionalization that I see is tribunals sort of making it a part of their procedural order. So retired judges as arbitrators have a very detailed procedural order. So if a technical member happens to be on a tribunal of 3 members where he's there, he will get that experience and he will adopt it in an arbitration. But unless those individual sole arbitrators happen to be a part of a 3-member tribunal where there is a judicial member also sitting, and this is all new, it's going to be difficult to navigate it, I feel. Which is why, unfortunately, there is a large percentage of awards by technical members which get set aside. And the reason is, while on the technicality it is sound, it lacks reasons and it sometimes also lacks law. I mean, an award needs to have reasons. That's what the statute says. The only situation in which an award cannot have reasons, which it can, is if the parties say in the agreement that we have both agreed that the arbitrator need not give reasons for the award. That's also an option available to the parties. But this is a practical problem we face with technical member awards, and which is why, I mean, I am very invested in these kind of workshops where we get to speak to the non-legal, non-judicial, maybe I should say, not non-legal. I think chartered accountants are all sort of from the legal domain, but the non-judicial side where I think it's very important to understand that that the reasoning part of it is very important. I mean, we don't need just the balance sheet and the numbers at the end of the day. It ought to be explained as to how did you arise. In most awards, in most disputes, there are 2 components. One is liability and the other is quantum. What the technical members always get right is the quantum, but the liability is where there is a challenge. And the liability part basically means it's a contract. You have to see who's responsible for breach, what is the breach, and why did that breach happen. Most awards that we see which get set aside from technical members are awards which say, okay, this A had to build you know, an ROB, and he's done it right, and he needs to be paid. And he needs to be paid X, and this is the calculation. So on the liability, unless you give reasons as to, and those reasons have to come from the evidence, which is the documentation. How does a judicial mind come to a decision that that a party has performed its obligations under the contract, that a party is not in breach of its obligations under the contract? All of that needs to be collected from the evidence and not in thin air. So I think that is very crucial. I'm sorry, it's looking like a dialogue between the 2 of us.
Let's continue. We'll take question at the end now.
Okay. So this is on the timeline effectively. Pleadings have to be completed within 6 months. The tribunal has to then render an award within 12 months. 6 months, parties can agree mutually before the tribunal that, you know, if the tribunal says that I need more time to write the award, they can mutually agree. But post 12 plus 6, if the tribunal is not ready with the award, we have to make an application in the court. Grounds for challenge. So there's the timeline for grounds for challenge is 3 months. So once you get an award, you have to, if you want to challenge it, you have to, challenge it within 3 months. There's a extension which is available of only 30 days. Courts are very strict with these timelines. There have been awards which where the challenge has failed, where the challenge came, let us say, 2 days outside this window. There is no provision which will allow you a window outside 3 months, 30 days if you're not able to explain what happened. Who can be an arbitrator? Somebody had asked me on the qualification, so this is the slide on that. So it can be a person of any nationality. Again, all of this will be, subject to what parties write in the agreement. So if you have not written anything, this slide, please read it as if you've not written any disqualifications or qualifications in the contract, and that is when this works, which is a person of any nationality can be appointed. Before the 2019 amendment, there was no qualification prescribed, but in 2019, this added a couple of qualifications in a schedule. That schedule was later repealed. So there was a requirement in that schedule that chartered accountants only with more than 10 years of practice can be an arbitrator, but that requirement is not on the rule book as of today. That list has been done away with. So yes, so the effectively means that parties are free to appoint regardless of their to give you maybe to simplify this further. Two parties can decide that they will appoint their neighbor as an arbitrator to decide their dispute. There is no qualification which is required to be an arbitrator, but what is important is that if that neighbor writes an award which has no reasons, then that award is of no value. So although the statute does not prescribe a qualification, the underlying concept of the award being in the nature of a reasoned decision is always there. So if you get a person who cannot give a decision with reasons, please do not appoint that person as an arbitrator. This should be of interest. So this is the last bit of the presentation. 4 areas where we are seeing people from the big 4 consulting companies, people with chartered accountancy backgrounds who are becoming involved in arbitration proceedings. One, of course, is an arbitrator, but mostly those are members who have had some experience on other arbitrations. I mean, I am right now not saying, but it's a chicken and an egg situation. How will you get an experience without being appointed as an arbitrator? But CAs are routinely now being appointed as arbitrators in financial disputes. Experts. Now, one important part of and role of experts and financial expert, it overlaps. One important part of every commercial dispute, and I mean, I primarily deal in civil commercial disputes where everybody is trying to get money from the other person. Now, in all of those disputes, mostly, unless it's a recovery, which is I've paid you X and I'm asking for X plus interest, in all other situations, there is a concept which we face, which is valuation of damages, valuation of claims. So in construction infrastructure projects, if I am for the contractor and I have built the project, but there is a time overrun on it, somebody needs to quantify how much money have I overspent? What is the period during which it has been overspent? Is it out of pocket, or is it something which the client is saying that, would have been my expense, but I have not incurred? Then on loss, I mean, if you have not completed the project, or if you have completed it in a longer period of time. In both scenarios, the contractor's margin of profit gets affected, and typically there is a claim that we make for loss of profits. Now, computing that loss of profit, there are several valuation methodologies available, which I think people in this room will know more than me. That is where we often need consultants and experts to help us with. But again, what we need here is not just the numbers, and this is again like a reminder that the tribunal and even the lawyer or the client cannot just work with numbers. If I come to a chartered accountant and I say, can you compute the damages that I have suffered in this project? Here are my papers. Ask me my financials, I'll give you everything. If you give me an Excel sheet, but you don't explain it to me and you don't give me reasons as to how you have arrived at those numbers, what is the methodology that you have applied, it is of less value. So more and more people with financial expertise are getting into this space, and they call themselves as valuers by and large, and they submit reports. So in our cases, we reach out to these people, and what we get is a report on claims, report on valuing claims, report on valuing damages, report only on profit claim. So we want to see what methodology will be adopted. Will it be a discounted cash flow method? Will it be some other method? And there can be hundreds of and every commercial dispute requires this. I mean, to give you a latest example, I'm working on a case without any names. This person, he was the owner of the project and the land, and he brought in a developer to convert his single screen cinema into a multiplex and a shopping mall. It got delayed. The developer didn't sort of do the job. And today we are in an arbitration where I have to make a claim for losses. Now, what are my losses? I mean, my mall never became functional, my multiplex never became functional for about 8 years. So how do you compute the loss that you would present? I mean, will you take market data and what would be that market data? Will you find out from other shopping mall Cineplex in the vicinity? Just like you do a property evaluation, you look at like a couple of houses in the locality and neighborhood and try and sort of give a number. So those are, I think, finer issues more and more. I think there's a lot of expertise which is coming in both in India and abroad. A lot of experts from abroad today are capturing this market, which is, I think, fully available to Indian experts as well. And it's highly lucrative. It is highly lucrative, if I may say so. Forensic accounting, I think, is the other area where we need. I mean, a lot of claims tend to revolve around the money trail, around fraud angle, and this is where again, consultants with CA background come in with their forensic accounting skills. So those are the areas where I think the role of chartered accountants is going to be more and more over the years. I think that's the end of, yes, I mean, that's just my office slide. Yes, thank you.
Thank you, Renu ji. We may have questions. Please come in. You may take your seat. Yeah. एक mic और दे दीजिए. So we'll again start from the back, because people sitting in front, they have luxury to raise hand and start the question. Sir, so this pillar is the middle. So जो pillar के पीछे हैं, उनका कोई question हो वो अपना please hand raise कर सकते हैं. माइक वाले भैया से मेरी request है, पीछे चले जाएं आप अभी. कौन सा पिलर है सर आपका? आप पिलर के आगे हैं सर. पिलर के पीछे अगर किसी का क्वेश्चन हो वहां जाइए लेफ्ट में.
In relation to arbitration, ICAI versus Indian law, etc.
Please keep your answers short so that you can take mic, Renu.
So it has two parts to it. I mean, because it is, I think a lot of news comes around the seat, venue issue, and it becomes a very fancy topic to discuss. In the domestic context, this concept of seat and venue has by and large no relevance. And I'll explain what is seat and I'll explain what is venue. Venue is physical venue where you're having a hearing. So two parties agree that we'll do an arbitration and the venue of arbitration will be, let us say, Mumbai. Parties may be from Mumbai, may not be from Mumbai. The arbitrator may be from Mumbai, may not be from Mumbai. But you've decided that you'll have hearings at Mumbai. If it happens to be a VC hearing, which we are all doing these days, will that venue of Mumbai be relevant? No. Can parties change venue? With agreement, yes. Tribunal can, in certain situations, also change the venue. Now, what is seat? Seat is basically the place which gives you the jurisdiction to court in respect of your arbitration proceedings. So where will you go for challenging your award? Where will you go for enforcing your award? Where will you go for any interim relief? Those are concepts which revolve around this word seat. Now, for instance, now again coming back to the domestic scenario, if I have an arbitration clause where two parties have said that seat is Delhi, venue is Mumbai, courts of Delhi. So what is seat? Seat effectively here is only saying that if there is any court litigation, any court proceeding that you need to institute in respect of arbitration, you will go to Delhi. Mumbai is mentioned as a venue. The problem sometimes, even in India, now, I mean, a lot of clauses get written very badly. So people then fight over the fact that because venue is Mumbai, and something else also is Mumbai, or the hearings happened in Mumbai, maybe the seat, let us say the clause doesn't say seat, the clause says venue Mumbai, courts of Delhi, does not use the word seat. Then the question will arise, what is the seat? Again, the law says it is where you can go to the court, and if the clause says courts of Delhi, it is Delhi. It has a different meaning in international context, but I'm assuming it's not of much relevance today.
So, any other question from the back? Now we will move pillar में जो मेरे right side में बैठे हैं उनका कोई question? क्योंकि left में आ गया तो फिर time ही नहीं मिलेगा. या mic वहाँ दे दीजिए.
My question is regarding the opportunity of arbitration in various forums. So what are the forums wherein CA can be impaneled for the arbitration, appointed as an arbitrator?
I mean, this is something I'm sorry, this is something I have not looked up for myself, but I think most, like I think DIAC, Delhi International Arbitration Center, FICCI has an arbitration center. I think most of them have a list of chartered accountants, if I'm not wrong. So you just like, you know, Google the list and you'll find it, okay. And you can apply for, I think, being impaneled.
Thank you.
Again, I think every institute will have its own criteria. Like for instance, for lawyers in Delhi International Arbitration Center, if you have to be impaneled, I mean, you have to, they open up applications once every few years, you apply, they ask you for a bunch of documents, appearances, reported judgments, and then we were even interviewed by High Court judges. So, I mean, it'll be a different qualification or an I won't say qualification criteria, but there will definitely be a criteria for you to apply to be impaneled.
So, any other question from my right side? No, let me move on to the left side. Red shirt. Chartered accountant in red. So, Mike, भैया जल्दी जल्दी चला करो यार, तुम्हारी बैटरी.
Madam, this agreement we need to execute separately, or it can just be a part of normal commercial contract?
Good question. It can be a part of the agreement also. It can be separately also. It can be in your emails also, but it needs to be there somewhere.
Right. Thank you.
You're welcome.
Pink shirt. Yeah. वहाँ दीजिए, वहाँ दीजिए.
Ma'am, while going through various commercial agreements, I generally observe there is a standard clause for arbitration that contains like arbitrator will be appointed through mutually and seat will be so and so. So what kind of other precautions one should take to save itself?
But what is the problem? I haven't understood.
No, I said that there is a standard clause in various commercial agreements that arbitrator will be appointed by mutual consent with both the parties and seat will be so and so. So what kind of other precautions one should take in that particular clause of it?
So I think the fact that it says that arbitrator should be appointed mutually by both parties is not problematic at all. That's a good thing. Providing seat is not a problem, but I think your question is how can I make my clause even better? You can don't confuse or don't provide too many, like court is Delhi. People write court at Delhi, exclusive jurisdiction Mumbai. That's conflict already. So, or people will write court is Delhi, exclusive jurisdiction is Mumbai, and arbitration will be held at Pune. So just be clear use the word venue as a venue, use the word seat as a seat, knowing what it means. And don't overcomplicate it by not specifying what it is. I think that's the suggestion that I would give.
So Mahesh ji, you have a question? आ गया सर, माइक आ गया आपके पास. महेश जी के बाद अमन सर की बारी है, अमन जी के बाद विजय जी की बारी है.
What is the fate of arbitration in India, as you will find a lot of luxurious litigant who is having the malified beneficiary, and they want to drag the cases from lower court to session to high court to apex court. Then, since they have an intention differently, they want to have the use as a coercive tool, judicial process.
I don't know how that can be answered. ये आपके CA profession में भी होता है, law में भी होता है. As long as the cost of litigation in this country will not increase, this will not stop. Till the time cost of litigation becomes till the time you make it prohibitively expensive for people to file frivolous cases, to file frivolous appeals, this will go on. And the other thing is, till the time you don't possibly introduce and implement higher ethical standards on professionals, both lawyers, engineers, chartered accountants, to be able to tell a client that you have no case, please do not file an appeal. I think those two situations are the only thing which will help, but that's futuristic. I don't think there's a solution to this.
That these are the settled.
You can't stop anybody from going to courts. The only thing which will stop you is if the court had to say you'll have to file 20 lakh rupees if you want to come for an appeal, and if I dismiss your appeal, I will recover 50 lakhs from you. That is the only situation in which it acts as a deterrent for you to think that I should not file a frivolous case. Only if genuinely I am wronged, I will file and pursue my case.
So I see it, Mahesh, differently. See, arbitration is an alternative dispute plan, wherein both the parties need to agree that we will resort it or resolve it outside the court. So it cannot come as a mandate. Secondly, justice cannot be costly. We cannot do what Renu suggested, but I feel, being, knowing the India, knowing the Indians and knowing the political system, I think it would be a tough task. It's good. We have both the mechanism available, but yes, we do need acceptance from both the parties to go into the arbitration. And if you and me do not agree, we may go to the judicial forum. And now let's come to Aman Behelji.
What I was asking,
if
both the arbitrators they are lawyers, and the past more than 2 years have passed, no judgment came in, no next sitting came in. What's the end effect of those arbitration? Means we don't know what's going to happen. After talking to you, I just went and talked to the MD of the company. He's also CA. He also didn't know. I talked to him, said, sir, 2 years the maximum period. And we just kept on mentioning this thing in the audit report that the arbitration is going on. But if you said that the 2 years the maximum period, then what was the responsibility of those auditors who are the advocates? Don't you think how they shouldn't have informed the parties what's going on, what's the judgment?
There is a concept today.
Please.
I mean, two concepts, buyer beware and ignorance of law is no excuse. So I cannot comment on what someone ought to have done, but now you know and possibly you can do some course corrective steps.
So now Vijayji will come to you. Mike, Amanji ki paas.
My question is on the binding force of the arbitration award. So, and besides the certain specific situations, you mentioned that it can be challenged on bias or such things and all that. So, vis-a-vis the professional indemnity insurances. Suppose there is a contract between the client and the professional, and so there is some misfound, and arbitrator is appointed, and arbitrator decides that so much damages should be incurred by the professional. So, and final award is available. So, will that award can be taken to the professional insurer, indemnity insurer, and that cannot be disputed?
So award. I'm so sorry. Award has the status of a court decree in the act itself. So an award is as good as a court decree. The day you have an award, after that 90-day period which is available for challenging an award, your award becomes enforceable. If nobody finds a challenge, you can go to court, file an enforcement, get your money. I mean, of course, the other party needs to have money to pay it. I mean, half of them are insolvent today. So it is final. The effect is, it is a court decree. An award is a court decree.
So before we break, we have last question coming from the back.
Ma'am, one question relating to valuation in a joint venture.
I'm sorry, I can't see.
Valuation in relation to a joint venture, ma'am.
Yes, sir.
In a arbitration context, while you have, the partners have signed a valuation in the agreement per se, the JV agreement, but our Indian accounting laws specify a valuation code in an international context. Which one will be applied? Can we challenge the contractual valuation versus the Indian valuation in an arbitral award? That is the award. Can it be done under the Indian international arbitration laws, valuation laws here, rather than what is mentioned in the contract?
I mean, I can't give you advice specifically on this, but
what is your opinion in law,
but
generally?
Broad principles,
Yeah,
broad principles. You can provide, I don't know in this case, but for instance, it's a JV agreement. You've provided certain valuation of the shares of the JV partners in the agreement. Tomorrow, if there is a dispute, whether somebody will go on market price, put in a valuation report or not, we don't know. What standards will apply to that valuation? To my knowledge, I don't think there is any restriction that valuation of shares of an Indian company, that too a private company, will only be governed. I'm sorry? Two partners. I don't know of any bar on valuation methodology to be adopted, unless you specifically again write in your agreement that when we have a dispute, these are the 5 methodologies you cannot rely upon. That also will be scrutinized by courts to see whether this kind of a restriction is actually an okay restriction to have or not have. That will also be seen.